Okay, people, it's like the next day. I don't know, I was up till like 6:30, 7 o'clock this morning. I went to sleep for 3 hours and then I got up again. So anyway, you know, I'm thinking, my brain is just going around and around and around and around and around and around in circles between the Property Act, the Guardianship Act, the Mental Health Act, the Hospital Act, the Consent and something else Act, and you know, the Community Regulations Act, and just, you know, like seriously people, like I have been reading this stuff like nonstop, trying to figure out a way how to put it down on paper where, you know, the court doesn't get confused and, you know, take the first thing that's handed to them by Fraser Health as face value. In other words, Fraser Health, as far as I'm concerned, is basically accusing me of sexually abusing John under the context of him being a child, and therefore the doctor somehow took charge of his life and appointed the social workers as the representative to him as in for power or enduring power of attorney, and then they gave him to somebody, but because they can't access the file because it's over 2 years ago, right? More than likely they don't have the file. That's why they don't know what happened to him, people. Right? They're just going to assume. They're just going to assume. That's what I'm waking up to right now. I'm just, you know, like, what is the common denominator here with Fraser Health in terms of what they're assuming and what they're suggesting? Because they are assuming and they are suggesting. They are not trying to get to the bottom of what happened to Uncle John, basically. They don't care. Right? If it's easy to accuse me, prejudge me, find me guilty, and then dismiss me with that, just another cloud over my head, people, as they continue to gaslight me, right? So that they can carry on with business as usual. Because if they did it with Uncle John, they're going to continue doing it with other people, and that's the point. Right? So, I don't know. Is this thing even working? I don't know. Like, seriously, I don't know. Like, I just don't know. I don't know how to put all those acts together to pinpoint the culprit, when in fact we know that it was a team effort. It was a group effort. The thing is, what kind of paperwork did they use to accomplish that? Because at the end of the day, Uncle John just was removed from the care center, the community care center, the community care facility. He was removed from there and then taken immediately to Victoria General Hospital emergency, because they were afraid he was going to have a heart attack once he realized what happened to him. Because 2 to 3 days prior to that happening, he was on video with me telling me to get a lawyer. And being that Fraser Health knows about my videos, they know about that because it's listed under my notice of claim, that particular video. So I'm sure they've watched it, but they're purposely choosing to ignore it and then misconstrued, contort, convolute the whole proceedings with suppositions of elderly abuse in a sexual sense, where the doctor had to come in and rescue John, as he deemed him to be a child, and then released him, and then threw away the file and forgot about him. As everybody ignored the fact that I was John's legal representative and had enduring power of attorney to not only manage his finances, but to carry on with his legal affairs. In addition to, we did that living will where we confirmed that on video under duress because of what Fraser Health Authority staff and their agents were doing to this family and Uncle John. Right? Him asking for a lawyer, and then 2 days later he disappears into emergency, into another hospital, as I'm being accused of God knows what on that end. And Fraser Health doesn't want to follow up on that, because it's easier to accuse me something in front of a judge or a master in a subliminal kind of a way through a gaslighting technique, right? That distracts away from what Fraser Health has done through their convoluted freaking rules, acts, and regulations that nobody really seems to follow, except for when it's convenient for them. They take a part from this act, a piece from that act, a little section from over there, and they convolute it into some sort of mosh-posh healthcare system that benefits the workers, that benefits the corporation, that benefits the crooks. And destroys families and innocent human beings. So I'm going to put this first, and then I'm going to put my rambling that I was probably rambling on for about an hour last night on this video camera, going through these different acts, trying to pinpoint exactly what these people did and how they did it. Right? Never mind what they did once he got over across the ferry onto the other end. Okay, people, so now it's like December 21st to like 20 to 3 in the morning. Like, seriously, man. Do you see this? I am flipping from act to regulation to act to regulation to act. That's the Patient's Property Act. There's the Power of Attorney Act. Currently, I'm reading the regulations for the Mental Health Act. This is what this is. Mental health regulations. You can see that. I'm looking at consent forms for treatment under involuntary patient. There's a couple of them here that they can use. They can use form 4, or they can use form 5. That's what I've read so far. And I read, hold on a minute. Like, seriously, people, I took the time to read 2 of those court cases. And, you know, again, what I'm finding is gaslighting techniques, because just with the type of court case that they chose in terms of a comparison, right, with, you know, Uncle John, and this one with this BD litigation, Guardian of versus Halton Region Children's Aid Society. That particular case relates to a 14-year-old girl that I guess was at school and did something, said something, I don't know, at school. Anyway, she accused her parents of molesting her or something like that. And then I guess Children's Aid Society got involved, and then they took her over. Oh my God. This camera is just getting worse, people. Serious. Anyway, they took over, you know, they took her over, right? Took her away from her parents. And then I guess and the other kids too, I think, from what I read, right? It's late and I'm tired. And so the parents took the doctors to court, the psychiatrists, because she ended up in an institution with psychiatrists for a couple of years. And so this girl, she suffered from delusions, and there was a long history of people committing suicide in her family tree. And so anyway, they're trying to say, when we went for the dismissal, that Uncle John was under the care of the doctor, and the doctor had no obligation to the parents. right, in terms of what was in the best interest of the child. And in this case, it was to be institutionalized under psychiatric care, and therefore there were no damages against the family because the family was the predator, basically. Right? I mean, first thing that comes to mind to me, people, is one, John has never been delusional, where he's been institutionalized. Right? And he sure in a heck wasn't an abused 14-year-old girl that became institutionalized for a period of 2 to 4 years under the Mental Health Act through the facilitation of the guardian, which in this case would have been the Children's Aid Society, after it was confirmed with doctors that that's what she needed as treatment. So I don't know how, I don't know why they pulled out this particular court case other than to intimidate me in terms of they know that I have a history with my grandson in terms of the Ministry of Children and Family Development, where my oldest daughter lost him under a wrongful apprehension, right? That to this day has basically destroyed her life and has interfered with the life of Andre's family in general, because that was the first time in my life where, oh, jeez, where I had any real interaction with social workers from that perspective in terms of like the Ministry of Children and Family Development, outside of looking after that little girl for the Ministry of Children and Family Development between the year of 2003 and 2007, for those 3.5 years that I looked after her, right, due to the Ministry of Children and Family Development. So again, I don't know how this applies outside of they're trying to intimidate me in a roundabout way through a gaslighting technique. In other words, if you continue to pursue the matter, you know, you're jeopardizing your relationship with your grandson in terms of having guardianship with him because you're rocking too many boats. I mean, that's what I'm thinking, right? Just in how they put it together in here, right? And just with the things that are being said and how they're trying to say that John was an oh, I think it's time to get rid of this camera, people. Serious, man. Maybe it just didn't like sitting there. Just how they're trying to treat John as a child that needed protection. But yet, on the other hand, before it even gets to this stage, there's certain forms that need to be filled out. And, you know, since the very beginning of Uncle John going into the Surrey Memorial Hospital, within that first week, things became convoluted to the point where nobody, if anybody, was telling the truth as to what was happening to Uncle John under the care of Fraser Health Authority. Was it just calcium pills that he was getting, or were they giving him medication and just not telling him or his immediate family about that? Was he designated to be mentally incapable? And if he was, were the correct forms and procedures followed? to go to the next stage if that was the case regarding his care. But then this is where it gets convoluted again, because this is what Fraser Health Authority is trying to say, what they did to Uncle John, and therefore the doctor has the precedence to the patient before the doctor has the precedence to the parents, or in my case, the representative, right? I'm not John's parent, but I'm his representative, and I also hold power of attorney, enduring power of attorney, to be his attorney for his financial affairs as well as his legal affairs. So I have a right to do this, people, because I still have enduring power of attorney, because there's been nothing forwarded to me in a legal sense to disbar me from that position. Right? But Fraser Health Authority, again, through their agents, in this case it would be the lawyer representing the corporation, is convoluting that fact by trying to distract the court away from it by casting a bad light on me, as if somehow I have now sexually abused Uncle John, as if he was a child, and therefore he needed the protection of an agency, but in this case it would be doctors, because if the public guardian and trustee would have gotten involved, I would have surely heard about it in that official paperwork that would require for them to do in order to revoke my position as attorney to Uncle John and his business affairs. And just his affairs, his business, legal, financial affairs. So, I don't know how to write that down, where an appeal judge will acknowledge that, especially if one is biased. And I feel like I'm walking into traps when I go to court, people. I feel that somebody's already, they're called ghost writers. You know, a ghost writer has already sat down, you know, scheduled me in to be number 13 on the list, right? Has specifically picked out certain court cases that kind of can, you know, put a bad light onto me to distract away from the real issues of what wasn't done in the correct way through Fraser Health Authority and their mandates and rules and regulations, just to avoid taking responsibility for the harm that they've not only caused Uncle John, but to his immediate family, including the representative to Uncle John, which would be myself. Uncle John can't represent himself. That's why he had me, people. Right? But for some reason, I wasn't allowed to exercise that right. Right? Because personally, I think Uncle John inherited some money from Joan Duncan, and I firmly believe that the Duncan clan withheld that information away from him for 13 months. And because when Joan died, Uncle John didn't want to ask if there was anything in a will, if there was a will that regarded him, because he didn't want to appear to his family to be only wanting Joan for her money. In other words, Joan died, did she leave me anything? He didn't ask, people. He didn't ask. We talked about it, and he didn't want to make it look like that's all he wanted was money. So therefore he felt that if Joan had left him something in terms of a superannuation life insurance policy, that his family would have, one, done the right thing and told him, and 2, would have been obligated by law to tell him. So therefore, he just never asked. Because that's not why he had Joan over here. He didn't have Joan move in with us for those 5 years, 4 years with us and 1 year in the, you know, the long-term care facility before she died. That's 5 years on the mainland with us. He didn't have her move over so that he could inherit money. But the minute they picked up her body, the minute that she died, left every possession that she possibly owned in this whole world here at the house with John and I, and just took the body, basically. I'm sure they were looking for that superannuation life insurance policy, and they more than likely found it. And then once they read the will and everything else and realized that John inherited something, they weren't quite sure how to tell him. So if you don't tell somebody that you inherited money for 13 months and the person is already elderly, what is that telling you about the character of the people that are holding that will, right? Obviously something not very good, because in that case they were probably hoping that John would either die, and then whatever was in that will left to him would just be forwarded to somebody else because he had died. Or you were hoping that he would get sick, like he did, people, and then step in, and because you're already in the system and you're familiar with how these acts work as in a healthcare professional, it's easy to drop that union seniority and the nepotism chain of command to get your own way, to cut corners, I guess you can say, right? They didn't want to go through the public guardian and trustee, because if they had gone through the public guardian and trustee, there would have been fees attached to it, and there just would have been a whole lot of kahuffle and hoopla, right? Because, you know, I would have been fighting, and John would have been in there saying, no, 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 you know, I'm fine. I just want to go home. You know, I've been in the hospital for 3 months, and I just want to go home. You know, let me go home. His extended family didn't want that to happen. And they wanted to cut corners. And they used union seniority and nepotism to do it. Right? Because they sure to hell didn't follow the rules, people. So when the lawyer comes and with these convoluted court cases that are designed as a smear campaign to distract away from the real facts, right, in terms of what they didn't do for Uncle John, right, and what they were supposed to do for Uncle John, and what they did to his immediate family ultimately by lack of doing what they're supposed to be doing, then you know, again, you know, is it staged before you even walk in? Are you prejudged to fail before you even get a chance to leave the gate? So, now, to be fair to Fraser Health Authority and the lawyers that had to read that notice of claim, I read the second, the last one, the last court case that they used as an example as to why it could be thrown out, right, in terms of not providing the material facts in the correct manner, or just you know, looking at it from a court perspective, like from a judge's perspective, or lawyers trying to determine the action, like You know, this is all new stuff for me. My brain is expected to act like a computer that already has the information in it, and it should be able to draw on that information within seconds, because my mind is a computer and operates like a computer in terms of logging information. Well, unfortunately, that's not my mind. So, you know, it is a complicated case in the fact that laws, federal and provincial laws, were broken to cover up the true agenda of what was happening around Uncle John. It had nothing to do with health care, people. Because if it had something to do with health care, Uncle John would have not shown up at the Victoria General Hospital all disheveled, on the brink of having a heart attack, on the verge of having a nervous breakdown, to which he did, people. If you lose 35 years of your memory in a very short period of time, that is trauma-based brain injury. Okay? They traumatized him so much that his brain shut down, because he wasn't allowed to talk about, to think about, or to acknowledge his immediate family that he had basically been involved with for 35 years. He didn't just live with me for 23 years, people. He has been in my life, well, now it's like going on 37, 38 years, right? Because he's still with me. He's still telling me to hang in there, that I'm doing a good job, that I can do this. Only I just don't know how to do this, because I don't know how to I'm trying, people. I'm trying. I'm going to try and use these acts and these regulations that come from the province of British Columbia, Canada. Now, some of them have been revised to import a BC Liberal Party agenda that isn't necessarily good for this province in terms of how we treat the elderly as a collective through the healthcare system under that pay-as-you-go service. But that's a different day. This is about Uncle John. Although he did get caught up with that agenda, in part for personal agendas, because even if Uncle John hadn't inherited any money from his wife, his family still went looking the week after they took him, and he was, who knows what he was doing at the Victoria General Hospital. But I can only imagine, it's like he said before they took him, that if they took him, he would have endless, restless nights. How much drugs did they give him to calm those endless, restless nights as he was completely separated from his loved ones and had no way of contacting them to get help? Okay? And I really do wonder if they gave him shock therapy to remove that trauma that they had created for the benefit of going to go look for that superannuation life insurance policy that they thought he had simply because he was a janitor for the provincial government back in the day and qualified for that benefit. Right? So whether he inherited money or not, they knew that if they could sever him from his immediate family and concoct a story around on how they found him so they could have the taxpayers pay as they went looking for that superannuation life insurance policy as he almost died, well, they did that. is a guaranteed sign of how many other elderly folk are vulnerable to that same process, people. There are 4.6 million people in the province of British Columbia, Canada, with a large number of those people being baby boomers going into the system. So for every 10,000, if 1,000 get caught up in the drama, like Uncle John's been caught up in, for simply a profit on a corporate level, and those bones for the corrupt personnel within the system to keep that food chain running, so I feel like Fraser Health is purposely convoluting the facts as I'm trying to express them for the benefit of allowing corruption to continue I do. So that it can continue to benefit financially. And it rewards criminal behavior. If they are successful at throwing this out and keeping it out of the court under this application, then they are rewarding criminal behavior. Because it is their duty to investigate criminal behavior and not bring in convoluted court cases again that, just kind of distracts away from the real issues at hand. So anyway, I don't know how to fix this problem. Seriously, people, if Fraser Health Authority wants to suggest to the court that somehow I abused or neglected Uncle John, then they need to be forthright about it. They need to come out and fucking charge me. Seriously. Because as I'm going through this stuff, like I'm still under the, I forgot already. Adult Guardianship Act. Right? I'm under Part 3. Because I'm trying to figure out how this court case that they threw in with this 14-year-old is applicable to Uncle John in terms of the doctor has a duty to the patient. Right? And then there were other instances where they were using other court cases within that court case that drawed on that same principle where the doctor was giving, a duty of care to a child. But yet, in the next breath, say that they released him as a fully functioning, viable, hulk of a man. And therefore, in that case, their base is still covered. That's what I mean, it's convoluted. So, support and assistance for abused and neglected adults. I'm trying to figure out what is the mechanism for the doctor to take the adult who's incapable and treat that adult as if that adult was a child, in the context of a child not being able to make those decisions for themselves, just like an incapable adult. And there's only certain things in here that would allow that to happen. right? Obviously, this act here was rewritten in the year 2003, because I have a supplement. I have a supplement that's backdated from, I'm learning, people, from September 15th of 2003. This was the prior one, the supplement, and then the new one, which would be this one. And then what happens is you get part 2, which is not in force. It says, see the supplement. So you look at the supplement, and that's what it used to read like, and now it's not there anymore, so it jumps. So I'm not the only one that jumps around here. It jumps, right? I noticed how it jumped in terms of how it was numbered. And then it brings you to what I was just reading, which I just lost. Part 3, I'm looking for part 3 here. It's going on like 3 o'clock in the morning now, if not later. Sometimes the time flies when you sit here, right? I still have to list the documents, people. Right? This is what I mean. I'm going around in circles. Right? That's part 4, administrative and miscellaneous provisions. So it's probably part 3. Right? Because that's what those social workers were doing. They were accusing me of neglecting John. I was abusing John. Right? Because I wouldn't agree to pay for convalescent care in the manner that they wanted it paid for. In other words, sign the form so that we could admit him on a continuous basis until we decided it was okay for him to go home. And that's not what he wanted. He wanted to come home, work on his exercises like he had already started to do, and continue to plan to go to Victoria for his mother's 100th birthday in July. And just get back to being Uncle John, a member of the family, right? That's all he wanted, people. Right? Nobody asks to get a flu. Nobody asks to, you know, develop an infection from that flu. Like I said before, he was lucky he didn't die from it, just for the fact of his age. Because lots of people die from flus. So anyway, this was written in 2003, after the BC Liberal government came in, with the elderly in mind, in terms of those baby boomers, right? So, of course, every government makes a projection in terms of where the money's going to be, you know, where the sinkholes are going to be, where, you know, the vacuums are in terms of, like, the money pits are going to be, and that type of thing, and where money can be gained. And so this is what I'm thinking. I'm thinking that they revived this act to make way for 15 to 20 years of baby boomers coming into the system, where health professionals can tap into resources, people, because my daughter would qualify for these so-called services, but she's not getting them because there's no money to tap into. As you read this statute, right, you realize that a lot of it is just centered around money and really nothing else, right? There has to be a motivating factor for people to act on the Mental Health Act, right? In terms of, you know, designating people as incapable and then taking control of their persons as if they were a child because the doctor said so, and then treating them in the manner that they seem, you know, that they think is appropriate to give that person quality health care. With an end result that doesn't necessarily meet what they say they're supposed to meet, right? Because again, really, Fraser Health should follow up and find out what the hell happened to Uncle John. He had a very torturous experience, people. Anyway, support and assistance for abused and neglected adults. You can tell I'm getting tired. Purpose of this part, 44. The purpose of this part is to provide for support and assistance for adults who are abused or neglected and who are unable to seek support and assistance because of physical restraint, a physical handicap that limits their ability to seek help, or an illness, disease, injury, or other condition that affects their ability to make decisions about the abuse or neglect. Definition. In this part, guardian includes a committee under the Patients Property Act. And this is where now you have to cross-reference everything. And this is where it gets daunting and it can get confusing, which is to the benefit of the corporation, especially when they're trying to protect criminal activity, right? Whether it's union driven in terms of, well, he's a union guy, you know, let him get away with it. That's what the union is there for, to protect the union workers no matter what they do and how they do it. Application of this part. This part applies whether an adult is abused or neglected in a public place, in the adult's home, a relative's home, a care facility, or any other place except a correctional center. So what? Are people in jail allowed to be abused? How does that one work, people? Ooh. This part does not override the right in Section 4 of the Health Care Consent and Care Facility Admission Act. I got that one too, people. And that one, let's see, this is where you have to go to Section 4. I'm just showing you what I'm doing here. Trying not to get discouraged. Trying not to give up. Trying not to have a nervous breakdown. Okay, here's Section 4. This is important, people. Right now, I'm not writing in the book. Oh, look there, you see. I'm not writing in the book. This time I'm taking little sticky papers and I'm just kind of sticky taping them off here. Just wait, I have to make sure I have the right one and not the supplement. This act is current. Okay, this is the current one. You got to be careful you're not using the supplement. It took me a while to figure that one out, but I got that one down now. Okay, so this part does not override the rights in Section 4 of the Health Care Consent and Care Facility Admission Act. Or, now I'm going to read you Section 4 of that act. It falls under Part 2, Consent to Health Care, Section 4. Every adult who is capable of giving or refusing consent to health care has the right to give consent or to refuse consent on any grounds, including moral or religious grounds, even if the refusal will result in death. I guess that would be like a Jehovah's Witness not wanting a blood transfusion or something like that. B, the right to select a particular form of available health care on any grounds, including moral or religious grounds. C, the right to revoke consent. D, the right to expect that a decision to give, refuse, or revoke consent will be respected. And E, the right to be involved to the greatest degree possible in all case planning and decision making. But he has to be capable. Yet, they said that when Uncle John left their care facility, they had no obligation to follow up on him. Right? Which makes you believe that they released him as a functioning adult that was capable of looking after himself and had no special needs. Okay? And because they can't locate his file, more than likely at this point, people, in terms of it's past the 2-year mark, because by law they're required to hold the file for at least 2 years. That's not to say that the file isn't there, it's just they're required to hold it for at least 2 years. And we're pushing on 3 years now, right? But I filed the notice of claim before the 2-year mark was up in terms of statute of limitations. So they should have been able to access it from almost the onset of me filing this application. So are they being truthful in terms of how they released him, outside of trying to suggest to the court that Uncle John was under child protection? Do you see how it becomes convoluted again? So we have to assume that they committed him based on the argument of Fraser Health. And then he must have had a reassessment in a day, and that reassessment absolved him. But at the end of the day, let's carry on with the Adult Guardianship Act. Application of this part. This part does not override the rights in Section 4 of the healthcare consent, blah, blah, blah. B, prevent the adult's representative, which would be me, people, or guardian, from refusing health care for the adult in accordance with wishes the adult expressed while capable, even if the refusal will result in the adult's death. I simply refused not to pay for convalescent care until it was the right decision to do so, people. When Uncle John was ready and willing to go there and want to be there for himself. When he really needed those services. Which, if it came to that point, would have ended up going into a long-term care facility. But before that would have happened, people, we would have moved from this house and moved into something more wheelchair accessible with a walk-in shower versus a bathtub where he'd have to try and get his leg over it because he had a difficult time getting his leg over the bathtub, you know, because of his injuries with the car accident, right? So, if it, you know, as his needs were changing, him and I were already talking about it, right, in terms of quite possibly having to move into a different kind of a house where we had different amenities to suit his changing needs, right, over a period of years. This part does not prevent an adult's representative or guardian from refusing health care. Okay. Reporting abuse or neglect. Anyone who has information indicating that an adult is abused or neglected and is unable for any of the reasons mentioned in Section 44. Now you have to go look for 44. purpose of this part. The purpose of this part is to provide for support and assistance for adults who are abused or neglected and who are unable to seek support and assistance because of physical restraint, a physical handicap that limits their ability to seek help, or an illness, disease, injury, or other condition that affects their ability to make decisions about the abuse or neglect. Again, there's that wordplay. Is unable for any reason mentioned in section 44 to seek support and assistance. May report the circumstances to a designated agency. Despite the Freedom of Information and Protection of Privacy and Personal Information Protection Act, a person must not disclose or be compelled to disclose the identity of a person who makes a report under this section. So, did those social workers report me to the designated agency? And if so, that designated agency would have had to have been, people, the public guardian and trustee. Okay, that's the only designated agency, as far as I'm concerned, that could start the ball rolling in order to appoint a new representative to Uncle John if they felt that I was inappropriate. No action for damages may be brought against a person for making a report under this section or for assisting in an investigation under this part, unless the person may have report falsely and maliciously. Now, you have to remember, people, okay, Andre was wrongfully apprehended in January of 2013, and we got him back in March, I think it was April of 2014. Okay, so that means I had social workers running in and out of my house, right, doing their reports, doing their assessments, doing all this stuff. You know, Uncle John did a criminal check, I did a criminal check, everybody did a criminal check, you know, we were going to court. Like, I think if there was any indication of elderly abuse, there would have been, like, issues then, in terms of they wouldn't have given me back Andre, people. Right? This is another reason why what happened to Uncle John is, like, so wrong. Because Andre had just basically hadn't even been home for a year yet. And he was just settling in with reestablishing his relationships with his family members. And Uncle John was one of those family members that Andre was establishing a relationship with. And like I said, prior to Uncle John getting the flu, I slept for a week straight, people, up to a week and a half, where Uncle John was basically looking after Andre for me while I slept because I was so sick. So for to suggest that he was being abused and neglected, if that was the case, it should have been dealt with when Andre was taken and when Andre was coming home. Again, there's that convoluted reality of wordplay that has an ulterior motive to use people as a commodity to prop up public institutions for the benefit of the union, because it just seems like it's just the union, the government workers that are benefiting from this, because I'm not just looking at Uncle John. The damage is already done with Uncle John and his immediate family. I'm looking at the numbers coming in for the next 15 to 20 years. Something that these judges or masters or lawyers or whoever are oblivious to. When in fact, they're the movers and shakers and the policymakers that are brought into society, to protect the next 15 to 20 years of baby boomers. But they don't seem to be interested in protecting them any more than they are interested in protecting Uncle John. No action for damages may be brought against a person for making, okay, whatever. A person must not refuse to employ or refuse to continue to employ a person, threaten dismissal or otherwise threaten a person, discriminate against a person with respect to employment or term of condition of employment or membership, okay, blah, 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 blah. In subsection 4, discipline includes a refusal to issue or renew a license or certificate. This is if you're a rat, right? And you rat out the abuse. You can't get fired for ratting out the abuse. Determining if the adult needs support and assistance. A designated agency must determine whether an adult needs support and assistance if the agency receives a report under Section 46. Now you have to go to Section 46. So what does Section 46 have to say? Oh, I just read it. Has reason to believe that the adult is abused or neglected, or receives... Wouldn't you consider medicating somebody without their knowledge to be abuse? Seriously, people. Do you want your calcium pill whole or crushed? I will never forget the way that woman used to come in at the Surrey Memorial Hospital. And they did it like that at the Yale Road Center. Would you like your calcium pill whole or crushed? Is John taking anything else? No, just a calcium pill. Would you like it whole or crushed? Receives a report that the adult's representative, guardian, or monitor has been hindered from visiting or speaking with the adult. They didn't want me speaking to John. They started to make it very uncomfortable for me to see John, right? Because they didn't want John coming home, people. If the designated agency determines that the adult does not need support and assistance, the designated agency must take no further action and may advise the public guardian and trustee. So who was the designated agency? Was the designated agency Yale Road Center? Is that why he was transferred there? That's not what the doctors told us. The doctor was the one that said that John would get extra physiotherapy there, right? Being that he couldn't stand up out of the wheelchair that one day when I went to go see him, and suddenly out of nowhere the doctor had released him because his lung infection had been cleared up. Yet he forgot to tell us that Uncle John was on opiates, and that was probably the reason why he couldn't get up. Not to mention that they weren't giving him very much physiotherapy at the Surrey Memorial Hospital, if at all, because there were few people that had that job description. Therefore, the doctor recommended that he go to the Yale Road Center because there he would get physiotherapy. But in this case, reading this act, I'm starting to think that maybe they sent him there for a brain scan. Oh, no, sorry, they did that at the Surrey Memorial Hospital first. Then they sent him to the Yale Road Center for a mental assessment as the designated agency to determine if the adult needs support and assistance. The designated agency may do one or more of the following: refer the adult to available health care, social, legal accommodations, or other services. They provided absolutely no legal advice, no legal services, and if anything, they tried to hide those things from him. The only accommodations that they wanted him for to be provided to him was convalescent care. By any means necessary. Have that on video, people. Unless, of course, they shipped him off to the country with the Three Stooges. That was acceptable. To strangers, complete strangers. And if he did run into those strangers when he went to his mother's annual birthday party, he would talk no more than maybe 5 to 20 minutes to those individuals in a Maj Podge party of the Duncan clan getting together for Mom's birthday. Everybody rushing around, you know. Oh, hi, John. Nice to see you. We'll see you this time next year. Assist the adult in obtaining those services. Inform the public guardian and trustee. Investigate to determine if the adult is abused or neglected and is unable, for any of the reasons mentioned in Section 44, to seek support and assistance. Power to investigate. In conducting an investigation described in Section 47(3)(d), a designated agency must make reasonable effort to interview the adult. In addition, the designated agency may. Now, I'm really curious to know if the Yale Road Center was the designated agency to interview Uncle John, because under their rules through the community care regulations and whatnot, you know, they were supposed to do assessments, a psychosis or something assessment, in addition to listen to the patient. But the thing is, the social workers didn't want to listen to the patient. They wanted to import their own opinions into the patient's brain and make that the reality, right? And that's why gaslighting techniques were used in the terms of that bell ringing on his bed randomly throughout the day, all day long, regardless of whether he was sleeping or not. And you didn't even have to touch the bed. The bed would just start ringing. And it had the sound of a parliament. When you go call the parliament into the legislative assembly, it rang the same type of bell. Because Uncle John and I, we used to watch the debates and whatnot, like the Legislative House of Assembly when that was in Parliament. It was better under the NDP because you could actually watch the debates, and we used to sit up to 6 o'clock in the morning watching these debates going on in the Legislative House of Assembly. But that was all changed under the BC Liberal government. Everything was all mixed up, and half the time you couldn't even find the debates. And then when you did find the debates, and they'd end a debate, and then you try and follow up with that debate, and you couldn't find it. And it's just they just tore it all up and made a big mess out of it, right? So besides that point, it was the same bell that would call all the MLA members into the chambers. That was the kind of bell that was on John's bed that would just randomly go off. And his roommate said that it woke up Uncle John quite often because it just kept on ringing. I have that bell on video too. In conducting an investigation described in Section 47, a designated agency must make every reasonable effort to interview the adult. In addition to, the designated agency may interview the adult's spouse, the adult's nearest relatives, the adult's friends, or anyone else who may assist in the investigation, and obtain any information that the circumstances required, including a report from a healthcare provider who has examined the adult, any agency that provides or has provided health or social services to the adult, and any person that manages the adult's financial affairs. Section 6.2 applies to information referred to in subsection 2b. So then you have to go to 62. Do you see how this works? don't forget, you still got the Patient Property Act sitting over there, and, you know, the Mental Health Act, and the Power of Attorney Act, and right to information. A designated agency, a qualified health care provider, and the public guardian and trustee have the right to all the information necessary to enable them to perform their duties, powers, and functions under this act. Any person who has custody or control of information that a designated agency, a qualified healthcare provider, or the public guardian and trustee is entitled to under subsection 1 must disclose that information to the designated agency, qualified healthcare provider, or guardian, public guardian and trustee as applicable. This section overrides any claims of confidentiality or privilege, except a claim based on solicitor-client privilege and any restrictions in the enactment. Okay. A designated agency that is conducting an powers to enter the investigation. So did they investigate me, people? Since I'm the target here, right? Power to enter the investigation. A designated agency that is conducting an investigation described in, because you have to remember, people, when they took him to Victoria and they rushed him to emergency, it's look how we found him. Oh my God. We went to the mainland. Look how we found him. He's never allowed to talk to those people again. Look what they've done to him. John, you know you're not well. John, they're not your family. John, they're not your great-grandkids. John, they're not your grandkids. John, don't look back. It's in the past. You're not allowed to talk to them until you're better, John. You know that, John. I'd like to see the paperwork around that. Serious. There should be paperwork around that, people. There really should be. And if it's gone to that extreme, which it has, then I should be charged for something that I didn't do. But if they're going to accuse me of it, then at least give me a trial, right, under my notice of claim to prove my innocence. Huh? How about that? Because as far as I'm concerned, Fraser Health Authority and their lawyers are trying to prevent that from happening, right? Because it's easier to cast a bad light on me, just as they did in those hallways within the Surrey Memorial Hospital and the Yale Road Center, as they were conniving in the background to basically steal Uncle John's money. Because if they were really that serious in helping people, again, they would help my daughter. But she has no money to tap into, so therefore anything that I'm reading here becomes non-applicable, because it wasn't written for my daughter. It was written for that baby boom coming in. That's just one big circle. Just wasting time on this camera. Just chat, 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 chat. It's because I'm overwhelmed with this, people. I know what I'm reading. I understand what I'm reading. I can see how they did it, but I don't know how to write it. Where it's acceptable to the court. Right. Power to enter an investigation. A designated agency that is conducting an investigation described in section 473 may apply to the court for an order under subsection 2 if someone from the designated agency believes it is necessary to enter any premises in order to interview the adult, and is denied entry to the premise by anyone, including the adult. So even if the adult says, I don't want you coming in interviewing me, the person that wants to interview them, in terms of like the social worker, can go to the court and get an order to force themselves into this person's house to interview them. I'm pretty sure that's what I'm reading. On application under subsection 1, the court may make an order authorizing either or both of the following: someone from the designated agency to enter the premises and interview the adult, a health care provider as defined in the Health Care Consent Care and Care Facility Admission Act to enter the premises to examine the adult to determine whether health care should be provided. Why don't they do that with all the homeless people out on the streets? They don't even have to knock on the door. All you have to do is just go find them on the cement. Right? But again, there's no money attached to that now, is there? If an application for a court order will result in a delay that could result in harm to the adult, a justice of the peace may issue a warrant authorizing someone from the designated agency to enter the premises and interview the adult. The court may only make an order under subsection 2, and a justice of peace may only issue a warrant under subsection 3 if there is reason to believe that the adult is abused or neglected and is, for any of the reasons mentioned in section 44, unable to seek support and assistance. Due to report offense. If a designated agency has reason to believe that a criminal offense has been committed against an adult about whom a report is made under Section 46, the designated agency must report the facts to the police. Well, I would think elder abuse is a reportable offense under number 46. Anyone who has information indicating that an adult is abused or neglected is unable, for any reason mentioned in Section 44, to seek support and assistance, may report the circumstances to a designated agency. Outcome of investigation. After conducting an investigation described under Section 473D, the designated agency may do one or more of the following: take no further action, refer the adult to available health care, social and legal accommodations or services, report the case to the public guardian and trustee. D has been repealed. Apply to the court for an interim order requiring a person to stop residing at and stay away from the premises. Apply to the court for an interim order requiring a person to stop residing at and stay away from the premises where the adult lives unless the person is the owner of the licensee of the premises. Well, this kind of sounds like that might apply to Uncle John, because that's what those social workers were trying to do. To stop, they were trying to get Uncle John to stop residing at and to stay away from the premises where the adult lives. So, was I under investigation and just didn't know about it? Not to visit, communicate with, harass, or interfere with the adult. Okay. Outcome of investigation. I think I'm reading this wrong. After conducting an investigation described in Section 473D, the designated agency may do one or more of the following. Apply to the court for an interim order requiring a person to stop residing at and stay away from the premises where the adult lives unless the person is the owner or licensee of the premises. Not to visit, communicate with, harass, or interfere with the adult. 3. Not to have any contact or association with the adult or the adult's financial affairs. To comply with any other restriction of relations with the adult for a period of up to 90 days. Apply to the court for an order under Part 7 of the Family Law Act for the support of the adult. Prepare a support and assistance plan that specifies any services needed by the adult, including health care, accommodations, social, legal, or financial. And here we go again with this convoluted bullcrap, because the way they took him over to Victoria, rushed him to emergency, look how we found him, had emergency department keep him for God knows how long and in what condition once he realized he was completely separated away from us, and he was told that was it. He was no longer going to talk to us and no longer see us, and that we were in the past and that he better get used to it, because he had no way to escape, people, right? Like, it just tears me up. It just tears me up inside. Like, you don't know. So, they used part of this legislation, what I'm trying to say here, and I'm just going to end it on this because this is just a whole bunch of fucking rattling. You can see how I'm struggling with this, right? In part, they used, part of this act, because this is an act, right, which is like a law, to convolute the situation at hand where they could commit white-collar criminal activity with a low probability of getting caught, because they used the family card in addition to union seniority, along with nepotism as a group think tank in terms of, you know, group hypnosis, I guess you could say, to get away with what they were doing, right? And again, you're dealing with people that know some of this stuff, maybe not everything, but if, you know, you're working around this stuff all the time, and, you know, you kind of get to know what you're doing and what you're not doing, versus me coming in green off the grass, right? Just coming in fresh. You know, this is the first time that I've actually really sat down and read this, right? And try and interpret it for what it is. So in one hand, you know, they use it to their advantage, but then on the other hand, they completely skip out other sections, you know, other parts to other sections. They only use half of the section to their benefit, and the other half they'll just ignore, because it's, you know, it's contradicting to what they're actually trying to do. In other words, you know, they removed him, right? Because it was easier to remove him than have me move out with the kids. They couldn't come in here and say, okay, you get out with the kids, Judy. Take your grandson with you so that Uncle John can stay in the house and live without you abusing him or neglecting him. Instead, what they did is they used this part, number 51 of the Guardianship Act, to take control of him under the premise of, you know, his sister. You know, I'm the sister, give him to me. I'll make sure I'll look after him good. You know, much better than she ever could, right? Even though I already had him for 35 years. Because, like I said, it just wasn't 23 years, people, right? And then just forget about, carrying on with a support and assistance plan that specifies any services needed by the adult, including health care, accommodations, social, legal, or financial. Well, no, they did that. They just didn't do it in the legal way, right? An order may be made under subsection 1E without notice to the adult or a person against whom the order is sought, if there are reasonable grounds for believing that proceeding without notice is necessary for the immediate protection of the adult. So, is this where Fraser Health is pulling out that doctor's card? The order was made by the doctor? Or is that supposed to be an order in court? If there are reasonable grounds for believing that proceeding without notice is necessary for the immediate protection of the adult. The immediate protection of the adult really kicked in, people, when we started talking about getting a lawyer. That's when they whisked him away as fast as they could. But mind you, by that time, they had already gotten his banking information through their bank fraud that, it was just a matter of time before it was going to happen anyway. On application under subsection 1E, the court may make an interim order described in that subsection if the designated agency establishes that there is a reason to believe the person has abused the adult and the adult is unable for any of the reasons mentioned in section 44C to seek support and assistance. Adults involved in decision-making, the designated agency must involve the adult to the greatest extent possible in decision about how to seek support and assistance and provide the support and assistance necessary to prevent abuse or neglect in the future. I don't know, people. I just support and assistance plan. Then it talks about a hearing. Review of orders preventing contact. Review of orders preventing contact. Emergency assistance. One, a person from a designated agency may do anything referred to in subsection 2 without the adult's agreement. If the adult is apparently abused or neglected, it is necessary, in the opinion of the person from the designated agency, to act without delay in order to preserve the adult's life. Like I said, they took him to emergency. Prevent serious physical or mental harm to the adult, or protect the adult's property from significant damage. Well, they didn't prevent serious physical or mental harm to the adult because he got injured, he was sick for months, and he lost 35 years of his memory, people. The adult is apparently incapable of giving or refusing consent. In the circumstances described in subsection 1, the designated agency may do one or more of the following: enter without a court order or a warrant any premise where the adult may be located and use any reasonable force that may be necessary in the circumstances. Remove the adult from the premise and convey him or her to a safe place. Provide the adult with emergency health care. Inform the public guardian and trustee that the adult's financial affairs need immediate protection. Well, I doubt anyone did that in Victoria. I really do doubt it, people. Take any other emergency measures that is necessary to protect the adult from harm. After providing the adult with the assistance and services mentioned in subsection 2, the designated agency may conduct investigations under section 48 and 49. You know, people, my daughter is having seizures on a regular basis. you know, being subject to quite possibly freezing to death now that the weather has gotten really cold, is subject to rape, you know, to beatings, to anything out there, people. And I don't see anybody acting on this act to protect my daughter. Absolutely none. Absolutely none. And it's like my other daughter said, and we agree, that if Fraser Health is successful at throwing this out, as in scraping off the plate, most definitely another lawsuit will be filed.